Hello, everyone. Good morning. We're going to take a couple of minutes for folks to come in, but welcome to this webinar, Cover Your Assets, Will and Estate Planning with Northwestern Mutual. We'll just take about 2 minutes. As folks come in, if you want to just drop a quick message in the chat and just say hello, it's a good way for us to know that the chat is working, and to just get a sense of who's here. So go ahead and say howdy when you come in. I'll say hello to everyone. All right, we have a howdy. Hi, Lily. Okay, great. Cool, the chat's working. We have several folks. This is really good. Excited to see you all here, and thank you for joining us in the middle of the day on a Wednesday. I'll go ahead and get started a little bit. So welcome everyone. Oh, actually, I'll let folks are still jumping in. I'll give it just one more minute. So welcome everyone. Thank you for joining us for this webinar called Cover Your Assets, Will and Estate Planning with Northwestern Mutual. So my name is Alex Mallett and my pronouns are he, him. By way of visual description, I'm a roughly middle-aged, or I like to say dad-aged, white male with curly hair. I'm wearing a collared shirt and I have a blurred background that would have instruments in the background. I'm in my home office today. And I'm the Development and Partnership Director at Folk Alliance International. It's really a great pleasure to be here as part of an initiative that many nonprofits are a part of, which is Make a Will Month. This is a really essential topic for just about anyone. It's really important for our community to understand this. And it's also a wonderful way to support causes that you love, including Folk Alliance, if anyone is so inclined. So we're really excited to be presenting this today. So before we begin, let's take a moment to note that we are joined today by folks from around the globe and to collectively recognize the importance, complexity, and difficulty of offering land acknowledgements in online events like this one. So I'm joining you from the ancestral land of the Osage, Kansa, Kaw, Kickapoo, Osage, Sakoan nations, also known as Kansas City, Missouri. We invite you to not only join in acknowledging the land that you're on, but also our shared responsibility to work towards reconciliation and to commit towards personal and meaningful action towards healing the legacies of colonization, forced migration, and cultural erasure. So if you'd like to drop a land acknowledgement in the chat, that's awesome. We are going to drop in a place where, oh, it's already there, where you can look up the lands that you are on. So now it's my great pleasure to introduce Jeff Hammer, who's a wealth management advisor at Northwestern Mutual. Jeff, I'm going to give you the floor.
All right. Well, thank you. Appreciate it. And first of all, I have to say, as Alex and I like to say, with both Hammer and Mallet here presenting today, you know it's going to be a hard-hitting presentation. So, but with that said, some of the things that you'll see, we enjoy a lot of the work we do in the planning space, especially folks that are in the creative industries. We've really enjoyed working with folks across multiple genres of music, but love the creativity that's there. Having seen just a wide range of different music, it's one of those things that is impactful. I get my energy from being around folks that have that sort of excitement and enthusiasm. And to that end, part of what we want to do is we're going to walk through a presentation around estate planning, and happy to also be available, afterwards to answer any questions that you may have. We'll have my contact information available. But With that said, one of the things that oftentimes we think about from when it comes to estate planning, we oftentimes think that we have to be Oprah Winfrey or Bill Gates, somebody like that, to say we need to have an estate plan. And what we really find is that oftentimes what we see there is that this is something for everyone. And when you think about it, one of the things I would encourage is think about, what does estate planning really mean to you? And in this particular case, we start by looking at what are those key components of an estate plan, and we're going to cover some of those as we go along. But it's really, what do you want to have in place when things change for you? And so when we take a look at that, part of the things that we look at are really going to be around what happens to not only our assets, which may include things like our houses, could be investments, could definitely be things like intellectual property that you may have ownership rights on. But it may also be not just about things that are financial in nature. It may be about some of the key components of what decisions do you want to have made later on in life, as well as after passing as well. And so as we take a look at that, some of the key things that we see with an estate plan is just going to cover those kinds of things that may have sentimental value to you. For example, if something there like, grandma's wedding rings, is that something, do you want to have a declared estate on how these things are going to be distributed out into whom? But also other things such as, let's say, if it's earlier on in life, what happens if we have children that aren't grown yet? What's going to be the plan for them, and how do we make sure that they're taken care of? There's a lot of issues there that can affect us no matter our age, no matter our tax bracket. And so basically everyone should have an estate plan. And it really is oriented around making sure that should something happen to you, your wishes get carried out. And so as we see that, some of the key things there is, in addition to it being not just about the money, part of what we would also see is, how do we make sure that it covers the thing when you can't speak for yourself? So in the event that, God forbid, you've passed or become incapacitated, there is clear direction there. And so with those common elements of an estate plan, part of what we see there is that we're going to be taking a look at, what are things such as wills and trust, but also other kinds of advanced directives. How to make sure, secondly, that the plan is evolving as your life is changing. Thirdly, how do you start to build an estate plan, and what are some of the things you can do on your own? And then lastly, when does it make sense to start to engage an estate planning attorney? There may be some things you can do yourself, but others, it's definitely going to be advantageous to make sure that folks have a very clear interpretation, because words can have very different meanings depending on the recipient. And so oftentimes when we bring up the idea of estate planning, one of the first questions we usually get is, what's included in that? And it's a good question, because it can be very different for very different people. So for example, two young men that were on my team, one of them has a very straightforward estate plan. He's still, sort of branching his roots out from parents, but at this point it's just him and about $10,000 worth of student loans and some assets that he's starting to build, and that's the extent of it. Another 25-year-old young man that works on our team, married, buying a house. They are anticipating kids within the next year. Also taking care of aging parents. It's a very different type of plan of saying, how do we make sure a broader range of needs are covered? So that's why you want to make sure that it's tailored. It shouldn't really feel like it's just something you grab off the shelf, because not everybody wears size 11 shoes. We may need to make sure that they fit correctly. And some of those things, again, may include some very simple documents, and others may require some more complex types of planning. But there are certain things that we would suggest that everybody over the age of 18 should have. And these three documents that you'll see here, they're going to include things such as the healthcare directives and a durable power of attorney. We'll talk more about what that looks like on the healthcare side, as well as also a durable power of attorney on the financial side. And the reason we encourage these is, so things like the healthcare directive, what we're seeing here is you want to make sure that you can structure it to get the type of care that you want. Different folks have different perspectives depending on the severity of their medical need. And so it is helpful to kind of declare that up front, because a lot of folks it can introduce an awful lot of stress on a family at a time where they're already under a high degree of duress, trying to figure out what is the right call to make. So, for example, if someone was seriously injured or became terminally ill, how far do you want doctors to go? And what are those steps that you would like them to take? Things such as CPR, feeding tubes, things like that. Do you want those or not? Do you want to be kept alive only if there's an opportunity for a cure, or just to say, hey, maybe we're done at that point? they're not easy questions, and so they do take some time to think about it. But again, thinking about it in advance is incredibly helpful instead of having family members have to figure that out in the blind. It can be very difficult for them to try to make those decisions and maintain family connectedness because folks may have very different opinions. So part of what we would look at there is by having those things legally outlined in a healthcare directive can be incredibly impactful. Now, in other cases, what you'll see there is this durable power of attorney for healthcare. And in this particular case, if someone's incapacitated, then you want someone identified who has the authorization to make medical decisions on your behalf. And in this case, this is something that can go beyond some of the advanced directives because some of the things that they may need access to, for example, are making those judgment calls where it may not be fully spelled out in an advanced directive. In other cases, it's also worthwhile to check that these durable powers of attorney have also capabilities to view and access your medical records. Obviously, that's a matter that has privacy associated with it. But if you have someone who wants to make the best informed decisions, they may need access to your records. And so that HIPAA authorization that you see referenced there is something that'll be critical to include in the durable power of attorney. And then also, one of the things that we see there as well is, and part of the reason we suggest that these should be in place for anyone 18 or older is because if you think about it, let's say you have a child who goes off to school or started working somewhere, and now all of a sudden they have a medical emergency. Once they're over the age of 18, you can't provide guidance on that. They are legally an adult. And so as a result, hospital staff can't tell you anything lawfully about their condition. And so you'd want to have these kinds of authorizations in place to say, how could I act on their behalf? Now, I think similarly as well, on the financial side, that durable power of attorney means that, if someone's incapacitated, they have the capability to act on your behalf, pay bills, handle taxes, handle other financial accounts on your behalf. But the key thing there is that they would have that capability to act on your behalf, because if you think about it, things like mortgages still need to be paid. Things like insurance policies may still need to be maintained, and you need someone to act on that behalf. Especially, for example, as for many of us, we may be in that sandwich generation where we're in the process of not only raising kids, but also keeping an eye on, aging parents and grandparents who may need our assistance. So they may need that roadmap and that authorization to act on multiple people's behalf. Now, one of the things you'll hear about is this distinction between general versus a durable power of attorney. And in the prior couple of slides, we've talked about this idea of a durable power of attorney. And the reason that a durable power is important is it stays in effect if someone becomes incapacitated and can no longer act on their own. And so whether that's because of an accident, because of there's cognitive decline, well, for whatever reason, this durable power of attorney can now stay in effect. A general power of attorney, that loses its effectiveness once someone becomes incapacitated. And so many times that's, I think, one of the key opportunities that we see when folks bring their documents for us to review is that they may only have a general power of attorney, which only works while they are of sound mind. And so as a result, the durable power of attorney gives someone that authorization to act on your behalf. There are other kinds of powers of attorney, but these are the two most common that we come across. Now, one of the things that we also see here is that there is that need to also update things, because part of what happens there is obviously over time there's going to be changes that occur. We may get married, we may get divorced. There may be beneficiaries that we've identified that may either no longer be here or that have been added to the equation. And so when we take a look at that, you want to make sure that things are continually being reviewed and updated on a regular cycle. I would typically suggest about every 3 to 5 years, look at it. But of course, if there's a major life event that's happened, then it's worthwhile to update these documents as well. I can't tell you the number of times as well that as we've sat down with folks, all of a sudden the angst that appears when they realize, hey, I've still got an ex-spouse listed as my beneficiary. And as you can imagine, most people aren't enthusiastic about that. And so, but the challenge there is a beneficiary designation will supersede a will or trust. And so we want to make sure that the beneficiaries are current. Similarly as well, as we've needed to do in the last year or so, as my father passed away, we needed to update some of our beneficiaries and say, okay, well, we need to remove him from some of those. And so some of the things we want to make sure of there is, again, once someone has turned 18, there may be very different roles and accesses that they may have. Whereas if one of your beneficiaries, for example, is someone that is under the age of 18, you may need to have a trustee identified that can act on their behalf while they're minors. Some of the other things as well that you'll see is you'll oftentimes hear reference to the idea of a will or a trust. And so we're going to dive a little bit more into that. And as we take a look at the differences between wills and trusts, some of the key things we see is that, both of them can identify who gets what later on after you're not here. But the other thing as well is that the will is something that, quite honestly, it can direct where certain things go, and it can also be very helpful for things that tend to be more qualitative in nature. So, say for example, who gets the baseball card collection, or who gets the original Les Paul guitar, whatever those different things may be, it can be worthwhile to identify those because again, it is surprising the things that can happen after someone's passing. I cannot tell you the number of times we've been asked to help sort through who gets grandma's china, and it's amazing the things that have sentimental value to them that, if it's not clearly identified, can become disputed with family members. But the other thing there is things like a trust that'll actually direct what happens to the assets that are owned by the trust. A trust can also be useful not only after you've passed, but also while you're here. So for example, let's say you're an artist and the career has taken off and you're doing quite well. And one of the things we actively encourage folks in that space, whether it's in music, film, sports, other kind of higher profile situations, is the reality there folks can become a target. All it takes is somebody to take one swing at you at a bar or wherever it is you may be, and now all of a sudden, if you retaliate, are your assets exposed? So we encourage the idea of a trust because that trust basically puts a moat of protection around your assets. And the reason being is if someone slips on the steps of your house, they may say, Jeff pushed them down the steps. But if my assets are in a trust is an inanimate object that can't have an intent to harm somebody. So therefore, there's a very significant limitation as to what assets can be pursued. But as again, one of the things I do want to mention is, for emphasis, is that anything that has a beneficiary listed on it, so things like life insurance, retirement accounts, those will supersede a will. Similarly as well, things that are jointly owned. So if it's an account that has joint survivorship or a jointly owned home, for example, those will go to directly to surviving owners. And it also depends on what type of state you're in, if it's a community property state or not. So there's some real specific details that require the estate plan to be very specific based on the uniquenesses of your situation. So the wills and the trust really help map out who gets what and with what level of priority. One of the things that you'll also see here as well is kind of with the comparison of, a will versus a trust is both will, again, guarantee that assets get transferred according to your wishes, but the trust, you can again use it before death and after. Trust will bypass probate in the courts. And that can be a huge advantage because if anyone of you have ever gone through the probate process, depending on the court system you're in, we've seen that that's typically 1 year. You've seen some as long as 3 to 5 years to get things sorted out. And in the meantime, a lot is expended on paying attorneys to work that through the process. But the other thing that's is a surprise to many folks is that a will is a matter of public record. So if I was peculiarly nosy, I could go down to the courthouse and take a look at the wills of anyone that's passed away in the last year, for example, and see what happened to that. The trust is a more private matter, so it is something that is handled outside of the public record system. So if you feel or prefer that need for privacy in the transfer of your assets, that is something where a trust can have a very distinctive advantage. So in many cases, you may need both a will and a trust because the will may be very useful for things that are more qualitative in nature, whereas the trust may be worthwhile to declare ownership on other types of assets there. Now, with that in mind, and with this being, what Make a Will Month, most Americans are going to agree that it's necessary and important to have a will, but only 40% have one. And so this is why we encourage folks, just because, again, it's far better to leave a roadmap than to leave it for folks to decide how things are going to get distributed and then have to go through the court system. It's very akin to the idea of saying, you know, we're going to California, so we think it's this way, so we're going to take a right out of the driveway. And if you bring in other family members or other interested parties, everybody's got a different way of how they think they ought to go to California. If you can see that just with the simplicity of taking a trip, imagine if there's a division of assets and other things that are being sorted out, as well as protection of kids. Now, one of the things you'll also hear about is the idea of what's called an intestate succession. An intestate is just a legal term that means anyone who's passed away without a valid will or trust in place. And those laws vary by state. And so it really does matter as to what state you're going to be in, but also has there been any indication whatsoever that declares that? Because again, one of the things there is it's not just enough to verbalize it. We do see a lot of folks who have kind of had those oral conversations with folks saying, you know, so-and-so gets the house, so-and-so gets the cars, whatever else may be divided up, but that will have no legal standing in court. Unless it's written down somewhere, preferably witnessed as well. It's probably going to be disputed and can be disputed in court if there are folks who have a very different stance on things. I think as well, one of the things that we see a lot of folks needing to make sure is clarified is who would be guardian of any minor children. One of the last things that I think most people would agree with is that you probably don't want the courts deciding who has, guardianship and that right to develop and oversee the development of your children. You probably want to be more declarative of that, of who you would like to have in that formative role. And so with that, again, if there are kids involved, one of the key things we would look at there is, make sure first and foremost, name the guardian, revisit, wills and trust as kids may be added into the equation. And then as well, if you look at things such as the powers of attorney, make sure that those stay current, the healthcare directives and any beneficiary designations. Because you don't want to take any chances that it's not clearly documented. We have seen several cases when folks bring their existing paperwork to us that they may not have been updated in the last 10 or 20 years, and 3 kids have been added since then. And unless declared as such, they may be left out of the division of assets or provision. And so we want to make sure that those stay current. So as part of that as well, we do encourage that regular review of the plan. Because again, things will change. And as your life changes, as priorities change, as kids get older, as assets can oftentimes grow and become more complicated, you need to review that to make sure it still reflects what you want. Again, especially in this space, in the creative space, things such as intellectual property rights are huge. There are things there to make sure that, are any songs that have been written or performed, that all the appropriate registrations have been made so that there's traceability. One of the things, for example, that we find is, is there traceability and registration of certain music in other places around the world? Because effectively there is the international black box where royalties can get effectively trapped if they're not claimed within a certain period of time. And for example, when we were having some great conversations at the International Bluegrass Music Association festival a few years ago, got the privilege of sitting next to a gentleman from Ireland, and he was talking about how big bluegrass music was in both Ireland and Turkey. And he had a radio show that promoted in both those places. That's something that was a bit of a surprise to me, to understand that kind of appeal for the music, but also to recognize that there were probably a lot of royalties that folks had no idea were out there collecting dust. And if not distributed within a certain period of time, then there's a default distribution model that probably does not include the original creator or performer. So it's worthwhile to build that traceability of where everything is registered so folks know where to look. Because the last thing you want to do also is leave a scavenger hunt. It is a tough situation when a family member may have passed, and now all of a sudden they're also trying to dive through all the shoe boxes, all the file cabinets, things that may be kept in digital record as well, to be able to say, how can we get into that? Because that's another key piece we also see is, let's say if someone passes away and there are a ton of digital records or digital formats or masters or things like that, without the proper authorizations, different companies can't give you the passwords to access those. And so unless there's a release and authorization that includes things like digital assets and an estate plan, They can't necessarily go in and access your email, much less any online accounts or other traceable records there. So digital assets are a key thing that we're seeing need to be also a focal point as well for folks to know where things are at and to leave that roadmap for folks. So first of all, I'll pause for a second in case we have some questions through the chat. We have some more information here, but I want to pause in case there are some questions that are surfacing here. You've seen some good comments from folks saying they've learned the hard way. Appreciate your feedback on that, Mary, as well. And, right. And let's see, we've got a question that's come in as well. Yeah, and one of the other questions here was how often do we recommend updating the plan? Again, I would say at least every 3 years, more often if you see that there's been a change in the family dynamic of either the loss of someone or the addition of someone or a change in marital status. I think those are good things to do. And then in regard to requiring an attorney or a planner, I would definitely suggest that that's something that you probably include both. Reason being, your attorney is going to have some great insights in regard to what is the legal disposition, but also there may be some very unique financial dispositions there as well of, for example, what happens with certain types of assets. They may get different tax treatments, and so that may result in different answers for different types of assets. And so your attorney and financial planner should be working hand in hand to provide those updates. Good question. So is there a way to legitimize the artist's catalog? And I think one of the key things there is that is definitely worthwhile to work with an intellectual property attorney to capture that inventory of what's out there. We also do some work on the consulting side to help folks look at that as well. And part of what we see in that particular case as well is there may be a lot of distributed content, everything from YouTube content to streaming to any performance rights, any other songwriting credits, etc., copyrights, a lot of things there that need to be traceable. It does take some time, but there are some surprising gems that are out there. And I think part of what has been unique, especially in the age of gaming, but also in the age of content explosion, is as you now have no longer just the major movie houses, but you have Netflix, you have Hulu, you have a lot of other companies creating content, as well as the gaming industry is a massive industry where there was a recent article that was done by Vicki Nelman that said, the gaming industry is actually larger than the film and music industry combined. And there's actually been some very unique ways to sync music to the gaming industry. And that's creating a whole new revenue stream for songs that may not have seen, a lot of traction in the last few decades, and they're now coming back to life. So I think it's definitely a worthwhile conversation, and we'd be happy to chat offline about some of the steps that can be taken there. Detailed question, but does Taxi assist in any of this? And that one, I would actually, let me take that one offline if I may, but it's a great question there. All right. Other questions as well? All right. Yeah, okay, so a couple other great questions. So one of the things that we will be sending out and providing afterwards is there will be a worksheet that can provide some inventory of where a lot of your assets may be. And again, happy to follow up with that as well and help you think through, are there any unique assets that may be missing? Let's see. And can one set up a will, have it witnessed by one's doctor, for example, rather than going through an attorney? There definitely are a decent number of do-it-yourself wills. You have LegalZoom and things like that. I would say it really depends on the complexity of the nature of the assets involved and the types of issues that need to be sorted through. Reason being, some of the things that we may think that have a very specific designation and interpretation can be interpreted a very different way, depending on the legal justification. Oftentimes, I would recommend, while not a practicing attorney myself, an attorney can help assess that and to make sure that there aren't particular things that are being overlooked or that can be interpreted multiple ways. And then let's see. Okay, and the follow-up question from Andrew was in regarding getting an inventory of digital assets and IP. Again, that's some things that there are definitely folks that can assist with that. Again, I'd be happy to have an offline conversation with you about that as we also work with folks to help inventory what assets may be out there and where. Great question from Jocelyn. What is the most affordable way to set up a trust? One of the things I would suggest there is feel free to reach out to folks that you know, but also us as well. I know FAI has connection to several attorneys as well. But I think one of the things there is, also it's one of the key questions you want to ask on the front end is understanding what that cost of the trust will be. In some cases, attorneys may bill by the hour. In other cases, they may have a relatively standardized trust where they offer those on a flat fee basis. It's worthwhile to know. There's definitely been more of a move towards flat fee. But I think someone's complexity may require some additional tailoring beyond that. So there's advantages to both, but those would be some of the key things I would look at. And then, is there a need to delete or remove, cancel any wills? We may have started with digital companies if we start with another company. And so I think as well, one of the things that you'll oftentimes find in the language of any will that's out there is that it's usually dated as of a certain date, and typically there's language in there that'll say this will supersede any prior wills that have been created. So that way, if there is any concern, you can always refer back to that language to say this latest and greatest is the most current intention of our wishes. But if there are physical hard copies that you have around in a file folder or in a safe deposit box, probably worthwhile to get rid of that just because it can lead to some confusion, especially if there's been a change in direction where someone may have been in line to get something and now they're not, or if there are new family members involved. It may be helpful to remove some ill will there that can develop if the folks can see that they were in and now they're out. Good questions, though. All right. Well, continuing on, we'll have some space for a little more questions at the end. To some of the questions that were just asked, for example, part of what we're seeing there is that there are different models that you're going to see, some that are the do-it-yourself models, others that are work with a professional. And we've talked through a lot of this particular language. There may be a lot of documents that you can access online, fairly easily and pretty cost effectively. But some of the key things there is some of the templates you do have to be mindful of that they may vary by state. And so certain things may be allowed in some states and not in others. Again, it may also depend on if it's a community property state or not. So there are some risks that can be associated with some of the do-it-yourself estate planning. Now, I would say there is an exception there, and we'll get to that in a minute. But again, what we see there is, law is very complicated. In some particular cases as well, there are some details that can have legal implications. So, for example, sometimes they may not specify that, an heir may be able to receive certain assets until a certain age. I have seen some that have indicated until they've demonstrated some level of decision-making capability. That's a pretty ambiguous term. And because that may be, for example, someone may have the great judgment at the age of 18 to say, I can handle my own decisions. There are other people that may be 55 and can't be trusted with their own decision-making capabilities. But who's going to arbitrate that and determine, when is someone able to handle those kinds of decisions? I think as well, some of the other things that we would also want to see is, for example, there may be differences as far as if someone has a more do-it-yourself approach, you may see that they can specify things such as, we're going to provide for the support of someone for some period of time that needs our help. So it may be a special needs individual, it may be someone that needs some recurring income for a period of time, and support can mean very different things there. So, for example, we have seen folks very well intentioned, when there may be a special needs child or individual involved, and they're like, hey, we're going to leave the life insurance, we're going to leave the house to the special needs child to provide for them if we're no longer here and they still need care. Not knowing that with that kind of a gift, it very likely preempts them from most, if not all, state and federal benefits that they may have access to. Once they get above $2,000 is typically the threshold. That may disqualify them from any and all state and federal benefits. And so things like that, where it may be well-intentioned, with the do-it-yourself model, it can completely upend the type of care that you already have in place. So we want to be mindful of those things. Key thing I would say is an exception to that is the power of attorney for healthcare. One of the things that the states did agree to do is try to standardize that, because one of the things is, if there is a need for a power of attorney for healthcare, there's likely some level of urgency behind it, and we don't want to have a doctor trying to sort through what is the legalese of, is this level of care allowed or not. They wanted to standardize to be able to say, how can we make those determinations quickly and effectively? So that one, I would say, those have pretty standardized templates. So if you decided to have the do-it-yourself approach, that one's probably perfectly fine. But it is worthwhile to have that conversation with the estate planning attorney. Some of the key things we see there is they can really walk through the different options that you have, make recommendations that are very tailored to what you're looking at, but also make sure that your plan reflects your wishes. So, for example, we have seen folks that have specified things such as access to assets held within a trust may not be made eligible at the age of majority, of 18 or 21, depending on the state. One individual quite literally did set the age of eligibility for access to the trust to his son once he was 55. This individual wanted to make sure that his son had a productive life, was working, and so those are things that were specified. But I think as well, other kinds of considerations we come across may also be the fact that someone that steps into that space of being an heir may also have some real challenges there. We may look across our children, for example, and say, hey, if they were to inherit the family business, for example, and let's say we have a music-related business, if they were to inherit the family business, they would absolutely do incredibly well with that. In other cases, you may have someone who does not have that business aptitude, does not have the discipline to make that work. And so if you had 3 kids, one of whom has the aptitude and 2 of whom do not, do you want to necessarily hand the business off to all 3 kids when 2 of the 3 kids could outvote the one that has the competence? And so there are different ways of equalizing an estate and saying perhaps as one child gets the business, these other 2 children get other assets such as the house or and life insurance or other kinds of assets. And there are ways of valuing those, that there's a level of equity and fairness to that, even if the treatment is not necessarily exactly the same. And some things as well that we also see there is, in some cases, folks may look at their potential heirs and say, there may be folks who have complicating conditions. So let's say if there's a substance abuse issue, one of the last things somebody may need in that circumstance is to be handed $500,000, and then they may be dead within a month because of decision making. So is there a way of providing support, but in a way that's more measured, that provides ongoing levels of support and maintenance without putting someone in jeopardy? So lots of different provisions like that we'll see, and that's where the estate planning attorney can help in that space. And you do want someone who specializes in estate planning. It is a very distinct sector of the law. So someone who may be a good family attorney, someone who may be a good tax attorney or good real estate attorney, they may or may not be the right fit if they don't have this specialization in estate planning. So look for someone who has that distinction. As we talked about earlier, ask about the fees. Again, many are going to a flat fee model, others still bill by the hour. And check around, see what other folks have found as they've started to do their planning, but also engage both sides of the team there. Without the understanding of what financial assets are at stake, then the estate planner may be doing an incomplete job and not know it. So, and similarly, if the financial planner doesn't know necessarily what the intentions are, there may be things that are misaligned as far as account ownership. So should certain accounts be listed as joint accounts? Do we need to update beneficiaries? Do we need to shift those assets so that they're owned by trust, for example? That's why you'd want both sides of that party involved. And then as well, as you're working with the financial professionals, again, they can also help coordinate and serve as a bit of a quarterback for those conversations. For example, one of the things there is, let's say if I had a cardiologist and then, also had my general practitioner, doctor as well, and 3 or 4 other, specialists that were part of my medical care. One of the last things that each doctor is going to do is say, here, Jeff, you take the records and hand it off to somebody else. We trust you to communicate the message that here's what's needed for your cardiology plan of care. They know I'm not trained in that area. And so it's their job to communicate with each other. And so similarly, that may be a space that your financial professional or the attorney can serve as that quarterback in that conversation to make sure everything is being shared, but also to make sure that those conversations are happening efficiently so it doesn't become the telephone game of here's what I thought I heard and here's what each person heard, but you can have that triangulated conversation with all parties involved. And some of the things, for example, I know Alex and I were talking about this earlier, there are those unique opportunities to get everyone around the table, not only the advisors, but also even extended family members, where we've done that, for example, in a retreat type setting, to say, let's get everybody together so everyone kind of understands the direction of where we're going, what it is that we stand for, what it is that we'd like to accomplish, and how do we incorporate perhaps even succeeding generations' wishes into the planning. There's some great things that can come from that, and happy to explore that more with folks. But the key thing there is we do want to make sure that the goals of the financial and the estate plans align, because one of the things there, for example, one of the key pieces that we see there that I would say is oftentimes folks may be trying to save retirement accounts for beneficiaries and may quite honestly be spending the wrong accounts as they're going through retirement. By wrong accounts, what I mean there is in certain cases, retirement accounts can be exposed to double taxation. There are some worst case scenarios that we've seen that involve both estate taxes as well as the income taxes that come to heirs, where we've been able to model that in some worst case scenarios, folks may lose as much as 77% of a retirement asset if it passes between generations. And so more often than not, we will actually encourage someone to spend down the retirement assets because of that risk of double taxation and save other assets that may get what's called a step up in basis, where let's say if you got in on the front end and bought Apple at $10 a share, and and then now that initial $1,000 investment is now worth $1 million, that may be something that's worthwhile to say, let's let that receive that step up in basis, where instead of our tax being calculated as an heir at the original $1,000 that was paid for it, that step up in basis, the IRS resets the tax basis to $1 million. And so now folks are only getting taxed on any growth above the $1 million. So different assets have different tax treatments, and there's a lot of things like that to make sure that with the financial planner, where they can help determine which assets are best distributed in which ways in conjunction with you and the estate attorney. In this particular case, just because the financial situations do tend to change a bit more often, it is recommended that you talk to your financial advisor probably about once a year, at least, just to make sure that you understand what's happening with the various assets that you have. So with that, definitely want to open it up for some more questions, but key thing that I want to use as a summary statement here is, estate planning is something that is beneficial for everyone. It leaves clarity for folks that are coming behind to say, what did you really want to have happen? It gives you that capability to be the guiding force around how those things and those steps are executed. And it just leaves that peace of mind of saying, hey, it has not become a scavenger hunt on the back end. So with that, we'll jump into a few more questions here, and I appreciate folks adding those in. And so a quick question there. Yeah. So as far as ramifications of one spouse as U.S. citizen and the other as an immigrant, for example, beneficiaries in Canada, yes, there absolutely are some implications to that. And that is definitely something where we would also need to take a look at which assets are owned by whom, because there are some very different treatments, especially as we look at the estate tax thresholds. One of the things right now, the estate tax thresholds, right now they're set at roughly 13 million per person. So for many of us, that's going to be something that's a threshold we don't have to worry about, but that is scheduled to drop to about half that amount at the end of 2025. There have been some proposals, several proposals in the last few years that have come within a handful of votes of saying that threshold that you should drop to as low as 3 million per person. Now, 3 million still is a lot of money, but if you start to think about it, if you throw in a house, if you start to throw in a sizable life insurance policy, any investments, any intellectual property rights, which can have, again, some very punitive implications from an estate planning perspective. there are a decent number of people that are going to be over that $3 million threshold if that passes. And one of the things here that I'll mention that I alluded to in regard to some of the punitive aspects that can come in with the estate planning on intellectual property is effectively the way it works is, let's say, for example, using Aretha Franklin as an example. So roughly an $80 million estate when she passed, no wills or trust in place. And in that particular case, at the time, there was 11 million that could be excluded from her estate. So there was $69 million, however, that would have been subject to estate tax. And the estate tax at that point in time was about 40%. So roughly a $30 million estate tax bill was due. And part of what we find in that circumstance there as well is that the way that the IRS calculates that estate tax is they look at not just the current value of assets, but they are looking at over the next 70 to 95 years, depending on the copyrights, and saying that's the value of every time R-E-S-P-E-C-T and every other song she had was played. They're projecting that out using one of 5 different methodologies, and they accelerate all of that out your income at it's what's called a discounted present value. They accelerate all that into the current tax year. So the bill is usually due within 9 to 15 months after someone's passing on income that may not come into the family for decades. For some of you that may be older, you may remember that when Joe Robbie used to own the Dolphins, that's exactly what happened, where a lot of estate tax issues caused them to have to sell the Dolphins. Estee Lauder's family run into it. There have been plenty of musicians who've had these kinds of issues. So there can be some very distinctive planning that needs to be done around the intellectual property to say it may be better owned in a trust and not directly owned by the family. So another question here from, I believe it's Tarika. So if trust has a time limit or an expiration date, what happens after those years? It's a great question. So there's time limits on sort of a couple different things, some that may be very specifically called out within the trust. And in that particular case, the trust may need to be renewed, or there may be some provisions under which it can be extended. But I would definitely be mindful of that if it calls out a specific expiration date. In some cases, it may have a planned expiration date where it may just be waiting for someone to get to a certain, age of responsibility. And so there may be a reason behind it, but that's something to definitely understand. But I think also one of the aspects too with a trust is that it's better to do it earlier rather than later from an estate tax perspective, as well as for other purposes for Medicare types of assistance as well. If assets are transferred into a trust as effectively a deathbed type of transfer, the IRS tends to pull those assets back out and pull them into the estate because basically they are of the mindset that you're trying to hide assets from taxation. So if it's happened, typically 3 years is the window. If there's been a transfer into a trust within the last 3 years, there's oftentimes ways that the IRS can pull that back out and potentially expose it to taxation. So usually when a trust is put in place, I'll tell folks, hey, look, for the next 3 years, don't run any marathons, don't do any extreme sports, don't do the running of the bulls in Pamplona. Whatever it is, eat lots of salads, stay healthy for 3 years so we can make sure that this stays out of your estate. And then I believe Danielle asked, can an intellectual property lawyer work as a long-term advisor to a parent or spouse left with the management of an artist catalog? Absolutely. They can definitely serve in a great space there. I know, for example, one of the attorneys we do a lot of work with just helped a group that's in the Rock and Roll Hall of Fame just get the rights back to their masters. But also once these folks have passed, there's definitely going to be some complexity and some long tails on the potential royalties that can be coming in off of that. So the IP lawyer, I think, and also in concert with the financial planner, can be very helpful to think through the implications there. And then how much you should expect to pay for an estate plan that's fairly simple. It's a good question. I'll be honest, it really varies by where you are in the country. That one's going to be a tough one to answer. It may be a couple thousand. It could be more complex than that or more expensive than that. But oftentimes some of the attorneys that may offer sort of the flat fee type of modeling, they'll start to kind of itemize and say, if you wanted the estate plan, it may include a trust, it may include a will, advanced directives as well. They may have sort of a packaged price on that, but it will vary. And then Danielle, amount of music royalties need to be considered a financial asset. And is it better to look at the catalog as a financial asset opposed to intellectual property? To answer your first question, I would say, again, that we have been surprised by artists that we have worked with that have had the surprise hit that's come out of the blue. And so I would say, for example, there's one artist that in Canada that had an interesting release that they had 8-9 years ago. A song never got any traction. Then all of a sudden it got synced to a movie and then to an advertising campaign, and massive amount of revenue came in. As we look at that, we just don't know. So I would say it's worthwhile to be as comprehensive in the inventory of the intellectual property to the degree you have, because you just don't know what's going to get grabbed and can get synchronized, because theirs is definitely not the only one we've seen like that. And I would say to look at the catalog as both. It is both intellectual property as well as a financial asset, and so that's why you need a coordinated strategy on it to make sure that it's being protected on all fronts, but also can be monetized and capitalized on as best as possible. Let's see. And Flora, I had a question or comment. Found a trust nothing but trouble ridden and was completely unnecessary. And so I think it really depends on the circumstances that someone has, and it also depends on how it was crafted. And so one of the things there is it can be worthwhile to have a second opinion, as with most important decisions in life. As if you're looking at major surgery, it can be worthwhile to have the second opinion from another doctor. I would say similarly, if you take a look at the trust, it can be worthwhile to have a second professional review that, just say, did we miss anything, or is there anything here that's unclear? Because without knowing the details, I would suspect that there may have been some things that had terms that had lack of clarity in them, or that may have been overkill in some cases. So I would say that, as far as who should really have a trust, it really depends if we're starting to get beyond some fundamental level of assets. So if there aren't jointly owned assets, if there aren't assets that don't have very declared beneficiary arrangements, such as life insurance or a retirement account, when you start getting into things such as intellectual property and other unique assets, I would say that that's definitely a time frame to really start looking at having a trust in place. Things where you have the titling of an account that says, hey, it's a joint ownership, or it has a declared beneficiary, those will transfer just fine outside of the probate process. But beyond that, it gets tricky in a hurry. Good questions from folks. Others that individuals have. And seeing some other good questions or comments here as well. Sometimes it can definitely be tough to contemplate financial planning while trying to cover sort of regular bills and things like that. Definitely understand that. And one of the things that I would encourage there is oftentimes what we see there is there are some great opportunities there as far as how you might be able to get greater leverage out of existing assets. Quick example I give, and it's very analogous to these circumstances. I do remember, when I first started working with a trainer, gentleman was a phenomenal weightlifter that I had no idea. But I was giving myself the internal high five because I just set my personal best on my deadlift, and what I didn't know was that the guy showed me a way of just adjusting my technique just a little bit. And in the space of 10 minutes, I was able to lift 60 pounds more, just because he showed me a slight change that I needed to make. And I didn't become, significantly stronger in that 10 minutes. I just found a better way to do it. And so you'd be surprised, quite honestly, what folks can do with an extra $50, $100, $200 a month that can actually dramatically change their trajectory. And if there's more to work with, there's even more that can be done there. But Alex, I saw you had your hand up as well.
Yeah, Jeff, I had a quick question
Sure.
that was kind of another, I'm not allowed to write questions because I'm one of the hosts, but what are some examples of other types of assets that might be that you might suggest putting in a trust? Intellectual property, but also would it be alternative property investments, or what might that look like?
Definitely could be that. We definitely see things such as natural resources may be in the mix. So there's a lot of interest right now with land, timber, natural rights for things such as minerals. Even one of the more unique ones we've come across lately is oyster rights in the Chesapeake Bay. There's some unique ownership things that can be declared there. And I think oftentimes, without that inventory, there's a lot of things where those rights have to be maintained. So for example, somewhere back 60, 70 years ago, my grandfather got some mineral rights in North Dakota somewhere. And but about every 20 years or so, those rights have to be maintained and reclaimed to say that these are things that are still owned by our family. Otherwise, those ownership rights revert back to the state. So there are some unique things that you may want to spell out. Again, one of the things there, my dad did a lot with model trains, and I didn't have that same level of expertise and insight that he had, but he could look at a model train and say that one's worth $3,000, this one's worth $35. So having that insight and that capability to say, here's what these can be worth, there's a lot of great markers you can leave for folks to say, by the way, don't overlook this. The ring is not a cubic zirconia, it's the real deal. Those kinds of things can be worthwhile to call out. And but also I think things like intellectual property, if you have heirs that may have need to know about that, there may need to be a worthwhile sort of educational component of saying, by the way, these rights may go out for decades beyond my passing, and that can be worthwhile for folks to know as they're trying to keep track of that. Well, other questions from folks? All right. Well, it has been my pleasure to be here with you. And again, please feel free to reach out if you have some follow-up questions. I'm happy to answer those offline. And Alex, I'll turn it back over to you.
Okay, great. So there's one more question, how to follow up with Jeff. Jeff is going to send some materials, and we'll send it out to everyone that attended the webinar. Just a basic worksheet, how to go through some of these, some of the 101s covered on this. Obviously this is a very nuanced conversation, and Jeff and I were talking before. It's one that can be very personal and logistical at the same time. So I want to thank you. And also it's just a topic that's so important for our community members to really understand these things and to make the best of whatever assets that y'all work so hard for. And so we really appreciate your time on this. We want to thank you for joining us for this webinar presented by Jeff Hammer and sponsored by Northwestern Mutual. As always, we are Folk Alliance, and our year-round work is really only possible thanks to supporters like you. So if you feel inclined to make a donation to Folk Alliance at any time, we sure appreciate that. It helps us do our good work. And just to share as well, a part of this conversation around making an estate is the ability to list Folk Alliance International as a beneficiary if this is one of the causes that's nearest and dearest to your heart. So we want to thank you all so much for attending, and you'll hear again from us, and we'll catch you all soon, but have a great rest of your day.